Dispute resolution is an overlooked area for construction contracts. No one wants to think about it. The hope and expectation is that the project will go smoothly. But disputes do arise. And when they do, the dispute resolution language in your contract becomes very important. Too often, people rely on the default language in their contracts without considering whether it fits for their particular project. For example, you may be familiar with contracts that require arbitration over litigation or vice versa. But have you considered whether these provisions sync up in all your contracts for the same job? A common scenario is when the owner and general contractor agree to arbitrate any disputes, but then the general contractor doesn't have an arbitration agreement with the subcontractors. This could mean that disputes involving the same project, such as maybe a construction defects claim, have to be resolved in various forums and jurisdictions. So the owner and general contractor might be in private arbitration in one city, and the general contractor and subcontractor are litigating in state and federal court in another state. As you can imagine, this adds needless complication and expense, and it makes it much harder to resolve a dispute. Arbitration clauses in general require careful scrutiny. Sometimes parties agree to arbitrate, but they fail to define the arbitration process. Unlike lawsuits, arbitration is a private process and it's up to the parties to define how it works. If you don't address it or consider it ahead of time, you may find that you don't have the right to obtain certain documents or take certain depositions. You might learn that you've committed to paying tens of thousands of dollars towards arbitration fees because of the service that you agreed to use. There are many issues that can arise by failing to define the arbitration process ahead of time. Of course, we all want to avoid a dispute, but sometimes wishful thinking can cause us to overlook the dispute resolution language in our construction contracts. Taking the time to carefully review this language at the outset can avoid major issues when a dispute does arise at a later point. If you have any concerns or questions about the dispute resolution language in your contracts, don't hesitate to contact Saalfeld Griggs. There are many issues and payment. I don't know. That was the dry read.